There was a judgment entered against you at some point in time. Based on that judgment, they filed a garnishment against your wages, right? You filed an objection to garnishment. So, for example, one of the most common ones I get is when somebody's bank account has been seized and the defendant files a motion objecting to that garnishment saying the only money in that bank account is for my Social Security check and they can't have that money. That's a legal objection to the garnishment. What you're telling me is the garnishment shouldn't have been issued because the default judgment should not have been issued. You need to argue the judgment. A motion date as to Mr. Martin, what's your pleasure?
I guess if I would like to have a trial date with the ability to file a motion, if you just give me a deadline for that.
Okay. Has there been a jury demand filed?
No.
All right. So if I give you a bench trial date, maybe 90-ish days down the road, that'll give you time to decide if you want to file a motion and do so?
Yes, Judge, thank you.
Okay. And Mr. Martin, I'm going to try to answer your questions and interpret. I know we tend to speak our own language. Heather, can you give me a bench trial date around 90 days down the road?
We have December 17th, which is your regular general civil day. We can do maybe 10:30, or would you rather the afternoon?
That should work.
Okay. And that's it live or Zoom?
Live.
Okay.
Gentlemen, does that work? December 17th at 10:30 live?
It does.
It does for a plaintiff, Your Honor, at least until I check with a witness.
All right. Thank you. All right. So, Mr. Martin, when counsel refers to motions, he may decide to file a motion. Mr. Mueller, I'm assuming you're talking about a summary disposition motion?
Correct.
Thank you. All right. So he may decide that he thinks he's got a good argument that based on the facts in this case that are not in dispute, the law entitles his client to a judgment without a trial. So if he thinks he's got a valid argument, he's going to file a motion. He'll send that to the court. You'll get a copy of it. You'll have a chance to respond to that both in writing and orally. If I buy his argument and I grant that motion, then I will give a judgment in favor of the plaintiff and there will be no trial. If I don't buy his argument and I deny that motion, then we're going to go forward with that trial date. Do you understand that?
Yes, fully.
Okay. And counsel, what are we doing as to defendants 2 and 3?
I've already filed a default judgment on, let me just say which one, on magnumtools.com and I guess that's it.
I got defendant 2 and 3 listed both as magnumtools.com LLC. So I don't know if that's a typo on our docket printout.
I show only 2 defendants.
Okay, so that's just a screw up on our end. All right, so we've got a bench trial date scheduled December 17th, 2024. Anything else that you need from the court, gentlemen?
Nothing from plaintiff.
Mr. Martin?
Nothing from the defendant, Your Honor.
All right, good luck, gentlemen.
Thank you, Judge. Have a good day.
Thank you.
You as well.
Judge, next we have Citibank versus Bauer.
All right, give me just a minute.
Oh, yep, sorry.
This is the spirit of your needs.
Okay, all right. All right, I'm sorry, give me the file name again.
Citibank versus Bauer, the last one at 9:30.
Oh, I got it, thank you. Appearances on that file, please.
Navrat Francis on behalf of plaintiff's attorney record.
Good morning, Your Honor. Leslie Honig on behalf of the defendant.
Good morning, ladies. You've had a chance to talk?
We did. We're just asking for some discovery, 60 days, Judge.
Okay, I think that was a November 12th date. Is that right, Heather?
That was, Judge.
All right, ladies, we just going to adjourn the pretrial?
Sure.
That's agreeable.
8:30.
8:30 work?
Yes.
And written discovery, correct?
Yes.
Okay, anything else we can do?
No, Your Honor. Thank you.
Okay, good luck, ladies.
Yeah, so are you on mute?
You're not, Mr. West.
You got anything else, Heather?
Yes, we have, Mr. West, keep yourself muted. Don't touch it. JP Morgan versus Pupava.
Yep, I got it.
Thank you.
Appearances for JP Morgan.
Yes, Your Honor. Christopher Royce on behalf of the plaintiff.
Thank you. And did defendant show up? Melanie Pupava?
Well, Your Honor, we do have a Melanie Peacock who was served with the suit. I apologize. And
That's okay.
so I think we might have the wrong person. So if we can adjourn it 30 days, we'll probably get this one dismissed against the individual received and refile against the true person.
Okay.
That's
Ma'am,
October. I'm sorry.
ma'am, do you understand that?
Yes, it's not me, so you guys can do whatever you want.
Okay, okay. All right, Heather, what was the date? October?
October 15th at 9:15.
All right. All right. Thank you.
And
counsel.
do I need to show up for that or no?
I'm going to get you, I'll be in touch. Yeah, we'll have this thing dismissed. Before,
Okay.
But that's just a control date as we were talking about.
Okay.
So the court makes sure
Okay.
it continues to move along.
Thank you so much.
Thank you. Take
All
care.
right.
Have a
Thank you,
fabulous
folks.
day. Bye-bye. Bye-bye.
Heather, what else?
First Portfolio versus Anthony Wafer.
Good morning, Your Honor. Alexander Sarhan, P77252 on behalf of plaintiff.
Thank you. Mr. Wafer, can you hear us all right?
Yes, I can hear you.
Okay. All right. And gentlemen, you've had a chance to talk?
We have, Your Honor.
All right. Have you resolved anything, counsel?
We have not, we can, happy to let the defendant go with his objection. I can let you know, sir, what's going on our end, and I'll just defer to the court to make its decision.
Okay. Thank you. Mr. Wafer, I don't have your paperwork in front of me, so tell me what your objections are. What are the reasons for your objection?
So first, I didn't know nothing about this. So the first time I know something about this is where my check was like halfway gone. So I called my employer and they said that you have a garnishment out of the 34th District Court. So then I called the court and then I came into the court the next morning to file the objection to the garnishment.
Right.
And because I don't even know who First Portfolio Ventures is. And then they said the original company was CM something I never had a contract with. So that was first. And then the second thing that I had a problem with is they said that they personally served me at an address I never lived at. The documentation here at the court that gave me said the person was 5'10", 170 pounds, 45 years of age. I'm 6'5", 215 pounds. I don't think I look 45. So that's why I didn't get none of this, because they said they served somebody that lived at that address.
Right.
And then the other problem I have is they have a address at 7640 Marlowe Road, Belleville, Michigan. I don't know who supplied that address or how they got it, but the only way to get that address is they pulled my credit report without my consent. So they broke the law doing that, because the only way to get that address was to pull my credit report, because the person that lived at that address added me on as an authorized user to their credit card. So I never used that address in my life. So they probably pulled my credit report and seen, oh, here's another address. I can see if he lives here. And they went there and said that they served me. They said they served me there. But the person that lives there is him and his wife. And he's 6'4", 350 pounds. And he's only 30. He's 28. So, and they're Caucasian. So I don't know what black male they served at the address. So that was the two things I had a problem with. I could never object. I could never object to the first time because I never received anything.
Okay.
And then once they said they served me, they just entered it in the court, and then the court accepted it because I didn't know nothing about it.
Right. All right. So everything you just told me are reasons to object to the default judgment that was entered against you. Would you agree?
Yes.
Okay. What's up today is an objection to garnishments.
Mhm.
All right. There are very limited legal objections to object to a garnishment, none of which I've heard about. So what you need to do is you need to file a motion to set aside the default judgment.
Okay, that's what they said that. And you said that was called what again?
A motion to set aside the default judgment. There was a judgment entered against you at some point in time.
Mm-hmm.
Based on that judgment, they filed a garnishment against your wages, right?
Yes.
Okay. You filed an objection to garnishment. So for example, one of the most common ones I get is when somebody's bank account has been seized and the defendant files a motion objecting to that garnishment saying the only money in that bank account is for my social security check and they can't have that money. That's a legal objection to the garnishment. What you're telling me is the garnishment shouldn't have been issued because the default judgment should not have been issued. You need to argue the judgment.
Okay.
All right. So counsel, I'm assuming you have not been able to share any information with Mr. Wafer, convincing him that this underlying account was his.
That's correct.
Okay. All right. So Mr. Wafer, what I'm going to do is I'm going to deny your objections to the garnishment, suggest you file a motion to set aside the default judgment.
Mhm.
Then we can get into these issues because counsel didn't know he was coming in to argue that motion today. Right? You follow me?
Mm-hmm.
Okay. So based on what you're telling me, it may be set aside. I mean, all the stuff that you just gave me, it might be set aside at that point.
Okay.
Anything else?
No. So
All
I just
right.
walk into the court and do it. Can I do that over online or?
Well, it's possible to do it online. Whether or not you can, I don't know.
Okay.
So there's a form that needs to be filled out. You can access that form and email it to the court or send it through my file. That's fine. Or you can come into court personally.
Okay.
All right. Any questions, sir?
Nope.
Counsel, anything to add?
Nothing for plaintiff, Your Honor. Thank you.
All right. Have a good day, gentlemen.
Everything's.
Heather, what else you got?
West versus Gem Seal.
All right, gentlemen, your appearances, please.
Good morning, Your Honor. Michael Hanch on behalf of the defendants.
Daryl West, Roper.
Thank you. Mr. West, how are you feeling?
Terrible.
Well, at least you're not in the hospital. I can tell by your background you're at home.
I'm not in the hospital. I'm out just so we can deal with this.
All right. Well, good luck, sir. So I think what's up today is defendant's motion to dismiss. Is that correct?
That's correct, Your Honor. I know Mr. West had requested another adjournment. I don't know if the court would entertain that or not. Mr. West, I don't know if you'd like to discuss that with the court, but I just want to at least give Mr. West the opportunity.
We just have both spoken, and I think that an adjournment is in both parties' best interest to try and resolve the matter.
I'm not adverse to an adjournment if both parties agree. How far out would you like to go? You want to go out to my October date?
I think that would be fine, Your Honor, if it's fine with Mr. West.
Yeah, I think we made a presentation of settlement, and if he can resolve it for us, we'll work with that, and that's our position.
How about October 15th? Heather, what time you want to do that?
9:45.
Gentlemen, that work?
Works. What day is that?
That would be a Tuesday.
Yeah, Tuesdays.
This is McAvee.
Yes, good morning, Judge. This is Cassandra McAfee. Unfortunately, I'm trying to start by video, but it's not allowing me to.
Okay.
But I am definitely here.
We can probably struggle through without it. Who's representing Calvary today?
Mr. Royce, who must be in another Zoom.
Sorry?
Are you on
Yeah, I can.
Calvary
I can
versus
speak.
McAfee? All right, are you ready?
Hello?
Yeah, are you ready on that, Calvary
Yes,
versus
yes, I
McAfee?
am, Your Honor.
Your appearance.
Yes, Christopher Royce on behalf of the plaintiff.
Thank you. Ms. McAfee, today is the date and time set for a pre-trial. That is an opportunity for me to get some information about this particular file and hopefully move it towards a resolution and get it on the calendar. Counsel, have you had a chance to speak to Ms. McAfee?
Yes, I have, Your Honor.
Where are we at?
Well, I think that she's going to submit an offer, and then, which of course, on a Calvary case, I have to submit it to the client. But I think we spoke, and I think she's agreeable to a 60-day period of discovery.
All right, how about November 12th?
That sounds good.
Heather, what time?
8:30 is good.
Ms. McAfee, that work for you, November 12th, 8:30 in the morning?
Yes, it does, Judge. I really
All right.
appreciate. Thank you.
You're welcome. All right, discovery is an exchange of information and it is meant to be a two-way street. So I'm assuming Mr. Royce is probably going to send you a list of questions that he wants answered. He might send you a list of documents that he might think you have in your possession that he wants to look at. You can do the same thing. If there's anything from Calvary that you think you need to put together your defense, you can ask Mr. Royce for those documents or that information. Understood?
Yes, I do.
All right. Any questions, ma'am?
No, I'm all set, Judge. I really appreciate the time this morning.
You're welcome. Counsel, anything else?
No, Your Honor.
All right. Have a good day.
Thank you. Thank you, Heather, for your help.
You're welcome. Have a good day. Next judge is LVNV versus Jones.
I've got that one. Counsel for Jones or counsel for LVNV.
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
Good morning. Ms. Jones, can you hear us okay?
Yes, I can.
Thank you. Good morning. This
Good
is the
morning.
date and time set for a pre-trial. That's an opportunity for me to get some information about the file and hopefully move it towards a resolution. Counsel, you ladies have talked?
Yes, we have, and Ms. Jones does not recall this debt, so plaintiff requests 90 days for discovery so that we can have an opportunity to send her documentation to hopefully refresh her memory.
All right, so we'll just adjourn the pre-trial then, discovery until then?
Yes, please.
All right, so that date is December 17th.
Okay.
What time, Heather?
8:30 is good.
All right. And Ms. Jones, did you just hear my explanation about what discovery is, the exchange of information?
Yes, sir.
Any questions about that?
Yes, I need to know what type of information you're referring to, as far as this case is concerned.
Well, it could be any information you think that LVNV has in their possession that would help you prepare your defense.
Okay. All right.
Right.
Like I said, I don't even know who LVNV is, though.
Okay.
All right.
Well, that will probably be part of what counsel says she's going to send you.
Okay. All right.
She probably has some old account statements or something like that.
Okay.
All right.
All right.
Any other questions, ma'am?
Nope. That's it. Thank you, sir.
Counsel, anything else?
No, Your Honor.
Have a good day, ladies.
Thank you. You as well.
Thank you.
And that's it for right now, Judge. We're waiting for the other parties of the other two cases that are on.
Thank you. Okay, you're confusing me with Macomb funding.
Judge, that doesn't appear because the way that they scheduled this, Macomb funding is the plaintiff.
Oh, I got you. I got you. All right. All right. So according to my paperwork, we've got a defendant 3 is Serval. What about defendants 1 and 2, counsel?
Yes, Judge Kim Corbin on behalf of the plaintiff. You have entered a default judgment and actually an order of eviction was entered on August 9th. This case is a post-foreclosure case to get into the property and to terminate redemption rights. You entered that judgment. We haven't received any response from anybody. And the problem is there were a bunch of lien holders
So one of those lien holders is up for hearing today because we finally got service on them in Delaware on
Okay.
August 28th. So we're looking for a default judgment as to serve all underlying trust. That's
Gotcha.
SERV. So what I'd like to do is submit a default judgment, giving them 10 days, and it terminates their redemption rights. In addition to that, though, Judge, I need to bring to your attention the fact that I filed a motion to add as a defendant Deutsche Bank trustee for Novastar, and you entered an order on September 4th to add them, but I need a summons, and then I guess the next thing is to schedule a court date for that, and I'll get them served with the new summons, and
Okay.
and then we can hopefully wrap this case up.
Okay. So that would be defendant 4. Deutsche Bank. Okay. All right. Okay. So submit your default judgment on Serval.
Yeah, who should I contact about getting the summons issued, Judge? Because I submitted it with my motion. I guess I'll just call the civil clerk and ask her about getting that done.
Yeah. In the meantime, Malachi, can you check for that and see if it's in on base somewhere?
Yeah, I could check for that. I seen that it was issued, but I'll check to make sure.
All right. So we're looking for a summons so we can get Deutsche Bank added.
And a court date. Wonderful, Judge. Thank you. This case has been like a bar exam final. So I'm happy that you're right on board. So I'll get that judgment into you today.
It's a master class on property law, right?
Thanks, Judge.
Yeah. All right. Have a good day.
You too. Bye-bye.
Mr. Evans and Mr. Helminack, we're just waiting till 10:30 to call the defaults
Okay.
if the other parties don't appear.
Yeah.
Understood. Thank you.
Thank you.
Mr. Evans, what type of hearing do we have scheduled? You're muted.
Unmute
Still
yourself,
muted.
Mr. Evans. Unmute. Hit the audio button. It has a red line through it. Down at the bottom. Yep, are you looking at your screen?
Yeah.
There you go.
There you go. What type of hearing is scheduled for today, sir?
Judge, Miss Poirier was hopefully going to show up today and show me how she's going to pay me.
Okay, discovery hearing? Okay.
Yeah, I was supposed to get her social security number and figure out how she's going to pay me back.
All right. We'll give her a few more minutes, see if she shows up. Thank you.
All right. Thank you, sir.
Seeing Miss Poirier, looks like it's been 30 minutes. So what is your judgment amount? You're
Unmute
muted.
yourself.
There you go. $4,500, Your Honor.
All right. All right, if you submit a bench warrant in the amount of $1,000, I'll sign it. We'll see if that gets your attention.
Okay, sir. How do I do that now?
It's forms that have to be filed with the court.
Okay, I'll come up to the court, to the clerk office and fill out the forms. And I'm asking for what, sir?
I would bet they have the form available, a bench warrant.
Bench warrant. Okay, sir.
Good luck.
Thank you. Bench warrant.
All right, is it Helminack? How do you say it? You're muted.
My dad said if anyone asks, it's Smith. No, it's Halmaniac.
I like that. Say it again.
Halmaniac.
Halmaniac. Good morning, sir. So this is pretty unusual when the attorney for the plaintiff doesn't show up. So I'm going to dismiss this action. I'm going to guess that they'll file a motion asking me to reinstate it. If they do, you'll get a notice and we'll have that discussion at another time. Understood?
Yes, sir.
Any questions?
Not at this time, no, sir.
All right. Enjoy your day.
I will. You as well too. Thank you.
All right. Thank you, Mr. Smakowski. I am going to refer you to my probation department downstairs. They're going to schedule with you to come back for an interview and a sentencing date. Based on that interview, they're going to put together a report and a recommendation of sentence. You'll have a chance to go over that with Mr. Bowditch for your sentencing date. I will have read that report, then we'll talk about that report and anything else you want to talk about before I sentence. You understand all that? In the meantime, I'm going to put you on a personal bond. First two conditions are pretty obvious. One, stay out of trouble. Two, cooperate with the process so we can move you towards sentencing. Third condition is do not purchase, possess, or consume any mood-altering substance unless you've got a doctor's prescription. That means marijuana and alcohol are off the table. Understood? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court amount of $1,000 if you screw up on bond?
Yeah.
Any questions? You're all set. Go on downstairs. Front counter, they'll call your name, give you those dates. Enrique, you're welcome. Enrique Cano Hernandez.
Thank you, Your Honor. Thank you, Your Honor. For the record, Jeff Bottom. Yeah. Sir, could you tell us your name? Enrique Cano Hernandez.
Good morning, sir.
Your Honor, today is the concept for arraignment in this matter we wait for the briefing standing. We've also had a chance to pre-trial this case, Your Honor, which 2022 and 2019 case. On both of these matters, Your Honor, we have an executed plea agreement subject to court approval. In both of these matters, Mr. Cano will be pleading guilty to an added count of no operating license on person, and the understanding the original charges would be dismissed.
Thank you. Sir, do you understand your rights and options? You understand the possible penalty? Understanding this, are you pleading guilty to two counts of no valid operator's license on person? And are you doing so freely and voluntarily today? On January 7, 2022, did you drive a vehicle in Van Buren Township? Was your license suspended, revoked, or denied at the time? On November 4, 2019, did you drive a vehicle in Van Buren Township?
Yes.
Was your license suspended, revoked, or denied at the time? I'll accept your plea to both added charges, dismiss both the original charges. What's the status now?
Your Honor, he's working on, he has to settle an immigration issue, and then he'll get his CDL back. He has to get it on.
Okay.
Your Honor, the only thing that might come in, and I don't know, he was since 2022. Matter of fact, I think this year, he hasn't been incarcerated.
Since 22?
Yes, since 22. Matter of fact, I think it was this year. Yes. And I don't know if the judge would, if his incarceration matter the length. I think it was 11 days for this one, but he did 4 months. I think between here and Livingston.
Yeah.
Yeah.
How was he in jail on these files?
Here, it was possession of stolen property of the car.
Okay, so you weren't in jail on these charges.
Out of this court, a felony court, yeah.
Understood. All right. Okay. All right. And are you working now? Where at?
Like for myself, self-employed.
What do you do?
Construction, basically.
What kind?
Everything basically except driveways.
Okay. All right, we've got a speeding ticket from 2019, a registration plate charge from 2022, a no proof of insurance from 2022, $1,200 worth of tickets you've never done anything on. Why not?
Here.
Here.
I was told that's all I had. The driving suspended.
You were told by who?
The judge that I saw for because they put me on diversion.
Okay.
They said you have to take care of these 2 tickets, and that was these 2. I did not.
Okay, well, they might have been talking about misdemeanors.
Oh.
Yeah.
With a civil infraction, if you civil, if you also default. Oh. If it's a misdemeanor, you get a warrant. If it's a civil infraction, they just assume you're guilty. Oh. Well, I have to take care of all of them now, no matter.
Are you in a position to do that?
Right this second, no, but I can do it within the next 2 weeks.
All right, so those tickets are $1,281. You can take care of that in 2 weeks?
Yes.
Okay, so By the 9th? All right, that takes care of that pile of money. Anything you want me to consider before I sentence you on today's files? All right, normally on these charges, I would assess fines and costs and 4 days on the court work program, but given the fact that we had you for a while on some other files with jail, I'm gonna waive that. You're welcome. All right, unfortunately, because these files are so old, and we haven't seen you, you've racked up some late fees and penalties. So on each of these files, fines and costs is $650. I'm going to let you set up some kind of payment plan or payment arrangements downstairs today. So before you get out of here, have a paper plan on how we're going to get our money on those. All right, whether or not that's a due date, you're going to pay it all, or if you're going to do it over payments, however you do it.
Yeah, I didn't make payments on first.
Yeah, yep. But before you get out of here, I need that on paper.
Okay.
You're all set.
Thank you. Thank you, Aaron.
You're welcome. Aaron, is it Franchuk? How do you say it?
Franchuk.
Counsel, your appearance.
Good morning, Your Honor. A piece of sound for Defendant, on behalf of Defendant, Aaron Franchuk, you stand to my right, you state your name for the record.
My name is Aaron Stephen Franchuk.
Good morning, gentlemen. Tell me about the plea.
Yes, Your Honor. For the purpose of arraignment, like waive formal reading to stand mute.
Done.
I did have an opportunity to speak with the prosecutor for purposes. We reached an agreement in this matter, Your Honor.
Go ahead.
To dismiss the original 2 counts, it's going to be a section of civil practice. My client would plead responsible for the double parking.
I see that, and he's agreed to pay fines and costs of $400.
Yes.
All right, I'll do it on the civil infraction, Heather. And can you pay the 400 today?
I can pay next week.
We do 14 days, Your Honor, if that's
Sure.
Thank you.
All right, both original charges are dismissed. Hold on, what do we got all here? Except for. All right, you've got something coming up for a review on January 5. Oh, offer sent to attorney on 12/9, must respond by 12/17. Are you handled some civil fractions for you?
Civil fraction.
Yeah, that one I just talked about was a speeding 21 over. And then we got another one. Failed to signal observe, review set for 12/18/25, still in pending status. Yeah, you might want to check those downstairs so we don't miss a deadline.
Absolutely.
All right, have a good day, gentlemen.
Thank you.
You as well.
Thank you.
What's this pile up here?
Old scratch.
Yaman El Ahmad?
Good morning, Judge.
Morning.
Half of Mr. El, say your name for the court.
Young officer.
So
You
you're,
just need a new date?
yes,
Okay,
the arraignment, he stand mute when he's reading out the information.
all right. You working? Go ahead.
He is requesting a court appointed attorney to the trial.
Okay, all right. You're working? Where at?
Lowe's.
How long you been at Lowe's? Heather, can we do a pretrial 212?
Yes, Judge Martin. Is his last name ELHMAD?
Yep. What time,
Fine to me, or we get different?
No, it's signs view.
Okay.
who, or what time we doing that?
212 is gonna be 9:30.
And you said that's Judge Martin?
Correct.
All right. Sir, I'm gonna put you on a personal bond. First condition and second condition, both are kind of obvious. Stay out of trouble and show up for your court date. Third condition is do not purchase, possess, or consume any mood altering substance unless you've got a doctor's prescription. That means marijuana and alcohol are off the table. Understood? Can you abide by those rules? Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you mess up on bond? Any questions? You're all set. Just wait a minute. We'll get you a paper notice. Haley, is it Matthew? Did I pronounce it right? Counsel?
Morning, Judge Dion Patillo, P 82378, on behalf of Ms. Matthews. State your name. Hazel Manfield. So, Your Honor, as to your name, stands immediately way reading. I have opportunity to discuss this matter with the prosecutor. There is an agreement to dismiss the original charge of operating while intoxicated, and Ms. Matthews would plead to operating while visibly impaired.
Thank you. Ms. Matthew, did you discuss with counsel your rights and options? You understand all those? You understand the possible penalty for the added charge? Understanding all of this, are you pleading guilty freely and voluntarily today? Counsel, if you would voir dire, I've got an incident date of October 9 this year.
Ms. Matthews, state your name for the court again one more time. And were you in the city of Van Buren Township on October 9th? Were you driving a motor vehicle? Prior to driving that motor vehicle, had you consumed alcohol? And do you believe that alcohol impaired your ability to satisfy?
I'm satisfied too. I'll dismiss the original charge. All right, Ms. Matthew, next step is I'm going to send you downstairs to the front counter. Probation is going to schedule for you to come back for an interview and a sentencing date. All right. I'll also put you on a personal bond in the meantime. Did you hear me do terms on the last one? First one is stay out of trouble. Second one is show up for your court date. Third one is, all right, raise your right hand. Raise your right hand. Do you swear or affirm and acknowledge the debt payable to the court in the amount of $1,000 if you screw that up? Any questions for counsel before I let you go downstairs? You're all set.
Thank you.
You're welcome. What was the name on that one I just handed you?
Yeah.
Feldkamp. Stay where you're at. We're just going to get you an adjourned notice date or adjourned date notice. So we'll take care of that. You're welcome. Front row, you're all together? All right, back row. All right. I'm doing my on base.
I hate one thing that happened each day. Get it done.
Just be honest.
Yes.
I didn't know.
Robert.
Yeah. Say that one. It's not really.
So needless to say, I'm not getting it all. In about 70. I think I'm changed. Where'd you go?
I thought you had a paper train. Thomas Makarski. Good morning, Mr. Bowditch.
Good morning, Record Jeffrey Bowditch, 45367, appearing on behalf of Tomkowski. Sir, could you tell the judge your name for the record, please?
Good morning.
Your Honor, today's date time set for breaking in this matter. We waived former readings. Also had a chance to pre-try this case. We have an executed plea agreement subject to court approval. In that agreement, Mr. Tomkowski will be pleaded guilty to an added, visibly impaired, understanding including charge with previous means.
Thank you. Sir, did you discuss your rights and options with Mr. Bowditch today? You understand your, those options you're presented with?
Yes.
You understand the possible penalty for the charge?
Yes.
And how do you wish to plead?
Yes.
Are you pleading guilty freely and voluntarily today? Mr. Bowditch, would you voir dire? Morning, Mr. Kaplan.
When are you actually?
Fence date was October 11 this year.
Mr. Markowski, on October 11th of this year, driving, sir?
I was.
You driving in van here in town?
Yeah.
Had you been drinking?
Earlier, yes.
What had you been drinking?
Yes.
Do you believe because of consumption of that alcohol, your ability to drive a vehicle is impaired?
Yeah.
Did you take the breath test, sir?
I did.
Do you have any reason to doubt or challenge the validity of that test?
No.
Your Honor, I don't believe we know the test. But, do you believe it was over the legal?
All right.
Yeah.
Defense is satisfied, Your Honor.
So am I. I'll dismiss the original charge.
Thank you.
All right, Mr.
This courtroom moment starts with the defendant desperately trying to explain why money was suddenly being taken from his paycheck. He tells the judge he had no idea a lawsuit even existed against him until his wages started getting garnished. According to him, the company claimed he had been personally served at an address where he never lived, and the physical description of the person they supposedly served didn't even remotely match him. At first, the defendant keeps throwing out every argument he can think of. Wrong address, incorrect identity, possible credit report issues, improper service. It sounds chaotic, emotional, and completely overwhelming. But then, the judge steps in and slowly takes control of the situation. The judge explains something critical. The problem isn't actually the garnishment itself, it's the default judgment behind it. And suddenly, the entire case changes direction. You need to file a motion to set aside the default judgment. The courtroom becomes almost like a legal lesson in real time. The judge carefully explains the difference between objecting to wage garnishment and attacking the judgment that allowed the garnishment to happen in the first place. Then comes the surprising moment. After hearing all the details, the judge admits something important. Based on what you're telling me, it may be set aside. And just like that, the defendant realizes he might actually have a chance to fight back. Because in court, sometimes people lose cases not because they're wrong, but because they never knew the case was happening at all. So here's the real question. If someone was never properly notified about a lawsuit, should courts automatically reopen the case, or should the original judgment still stand? Like and subscribe for more real courtroom moments.